The next matter to come before the court this morning is State of Ohio versus William Queen. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time, please let me know when you get started. I'm keeping the clock. You can also follow along on the screen regarding the passage of time. We have read the briefs and we're ready to proceed when you are.
Thank you. Now, as opposing counsel, may it please the court, Attorney Angie Killey on behalf of the appellant, William Queen, I would like to reserve 5 minutes for rebuttal, please. Your Honor, Mr. Queen's appeal is primarily a fact-driven situation, so I will not spend the time going through as I'm aware the court does read the transcripts and has all of that information in front of you. However, what I wanted to come in here today to touch on is primarily 2 issues. One of those being the felonious assault conviction, which was argued both as sufficiency and manifest weight standards, as we do believe that it was defective in both counts. Appellant was charged under 2903(11)A, which says no person shall knowingly do either of the following: cause serious physical harm, cause actual serious physical harm. This is not a case where we're looking at a cause or attempt to cause where we're using a weapon. There's no allegations of a weapon being used. Definition of serious physical harm does, of course, include a multitude of things under the statutes, and there's always a catch-all that is included in those. And I know from the state's perspective, the argument that there doesn't need to be any medical records, that's true. There doesn't need to be, but what we're actually in fact talking about in this case is an allegation of potential manual strangulation. Evidence of which that was presented by the state was the possibility of a couple of light bruises on the neck of the alleged victim in this case. Our position is that that does not rise to the level of serious physical harm, and a lot of that is factually based on the statements, not only just the medical evidence, and when she did go into the sane unit and had her determination, it was a couple of days later, so we really don't have any indication as to exactly where those bruises could have come from. They could have been related to any type of sexual activity, shall we say, which was discussed at the trial. She offered no information about any type of lasting pain, any type of long-term injury, there's no potential of death that was alleged. She herself told the detective that while it was taking place that she didn't tell him to stop, that she never lost consciousness, that there was no other physical injury as a result of the allegations that were made, and in fact she actually advised at one point to the same nurse that she thought that the defendant was simply into rough sex.
Counsel, the briefs that I read are pretty diametrically opposed as to what she said and she didn't say. Of course, like you said, we'll read the transcript, and most of the time we don't have the transcript available before oral argument, but regardless, the point is, I guess what I'm getting at is, you're saying she said, never said stop. The state's saying in their brief, she said stop.
Well, and I suppose part of that is a direct result of the victim giving different statements to different people, which of course we all know is not abnormal, but at least from my perspective, and I'm sure I don't recall off the top of my head, I did put direct citations to the transcript as to where she said those. She did have a little bit of differentiation in what she said on the stand too, as opposed to what she said to the same nurse and the detective, closer in proximity to the incident that is being reviewed. So from our perspective as the appellant, we would be inclined to say that the credibility of what is told at the beginning of the incident, when it's fresh in the recollection, would be more credible to believe, because it was closer in proximity when she told the same nurse that she thought it was rough sex. It was closer in proximity when she spoke to the detective. We're talking about, I don't even remember, roughly a year and a half later by the time she takes the stand. Memories can be a little faulty and things can change a little bit, but we're asking the court, that's kind of why I reviewed it in both arguments to a sufficiency and manifest weight, because there is a little bit of a credibility issue as it relates to the victim but there is no question that she had no long-term injury. And it's our position that regardless, a bruise on the neck does not equate to serious physical harm.
Counsel, I guess for the felonious assault, it wouldn't really matter anyway that she said no. You don't have to tell somebody to stop eating, you don't have to tell somebody to stop strangling you, right?
Correct.
Okay, so let me ask you this in regard to the strangulation claim. You say bruises on the neck, but what about her testimony that she couldn't breathe, she thought she was gonna die, and she went limp?
It's not what she told the same nurse, and it's not what she told the detective.
So but that's the argument that is being made, so that's just a credibility issue then, isn't it?
There is a credibility issue there.
Because if she testified to that, whether she was believable or not, that would at least go to possibility of serious physical harm.
More so too, but our position would be that there would need to be something to support that. I mean, if she's indicating that, understand that you don't have to have a medical documentation that says, okay, this person lost consciousness. If she's seeking out medical treatment for an injury that would equate to serious physical harm, then why was that not acknowledged from the get-go? Why was there no aftercare, any follow-up, any checking to see if there was any type of damage? A loss of consciousness in some instances can equate to what I would say is a serious physical harm, but there would need to be some medical documentation to support that. Would there be, was there any type of a hematoma related to that? Could there be any type of lost memory, anything along those lines? We don't have any of that. We don't have any type of follow-up with any type of mental health treatment that may have been appropriate if she had suffered that kind of trauma. The reality of, like, when we really pull back, if we take the credibility issue out because of the fact that she did tell opposing versions of fact to different audiences, then what we're really looking at is a couple of bruises on the neck, which our position would be is a simple assault. It doesn't rise to that level of a felonious assault.
Thank you.
And very briefly then, we would like to discuss the sexually violent predator specification. We once again do have very opposing views on this. But it is our position that quite simply the plain language of the statute says convicted 2 or more times in separate criminal actions. Our position is that one criminal action is one criminal action regardless of how many counts there may be, and the statute does not speak to the number of victims. Recognizing that there are other elements in the statute, and I know the state discussed that in her brief, the court didn't make any findings that any of these other aspects of the statute apply to this defendant, and there was no other evidence presented at the bench trial that was associated with the sexually violent predator specification that would associate to any of these other potential ways of seeing him or a likelihood that he would engage in future conduct. I think that really the court's decision is based primarily on the subsection of multiple convictions and separate criminal actions. We believe that it was one criminal action. And I think I would sort of liken it to the whole idea of like when we seal or expunge somebody's record. We don't look at the individual offenses that are contained within that specific case number. We don't look at how many victims there are in that specific instance. It's one course of criminal conduct, it's one criminal action, and if it is subject to being sealed or expunged, then it is of no matter how many different people are involved, and I think it should be treated the exact same way. If he had had 2 separate actions in Medina County, then it'd be a different circumstance. If they had indicted him under 2 separate case numbers, but they chose to do it as one, that is one conviction or one action for purposes of this specification. And I think that perhaps there should be a little bit of clarity in there. In my research, and there can be differing opinions as to how that is going to play out. And for something that is this serious as it relates to a sentencing enhancement, and we're talking about a specification that carries potential life punishment, and life incarceration is exactly what happened to this defendant, that if there is any ambiguity as to how this statute should be interpreted, then that should be to the benefit of the defendant until it is clarified for future proceedings.
Okay, this might be a silly question, but I'm gonna said about, it didn't matter how many victims were in one case, as long as it was still one case. And if they had charged each of this is a hypothetical, if they charged a separate case for each victim and had a separate case number, what if they consolidated the case numbers after they charged?
Then it would be my position that you would need to have a finding of fact by the trial court or something in the record to indicate that they were in fact different instances, not a continuing course of criminal conduct. What pops into my head with that, and I could be way off base, so stop me if I sound like that, but with venue determinations of whether or not crimes that are committed in different jurisdictions can all be tried in the same jurisdiction, what we look at is whether or not we're talking about a continuing course of criminal conduct. So in my mind, if they consolidated for like judicial economy purposes, then it would be very simplistic for the court to be able to say, we're doing this for purposes of judicial economy, recognizing the fact that these are separate instances of conduct.
And counsel, you're at about 4.5 minutes.
Okay. Then if there's no other questions, I would, okay, thank you.
Good morning again, Your Honors, and may it please the Court, I'm Jacqueline Corrigan again for the state as the appellee. There are again 2 reasons to affirm the judgment in this case as well. First of all, the felonious assault in this case, that conviction is supported by sufficient evidence, and then the manifest weight of the evidence supports the convictions, including for the sexually violent predator specification. And I mean all the convictions, I mean all of them. The rape, in addition to the felonious assault. I'm just going to be very brief, because Judge Carr, you were going through some of the evidentiary questions about what's in the transcript. I have to remind the court that the victim testified in open court that she had lingering pain from the bruises that were inflicted upon her by Mr. Queen's strangulation of her. Those were visible to her coworkers, not just the next day, but the day after, to the point where one of her coworkers urged her to go to the hospital. And so those were visible and painful days later. So it wasn't just immediately afterwards. She testified regarding the rape that she told him to stop. She testified that she told him multiple times to stop. And that's at pages 269 to 270 of the transcript. She testified that during the strangulation, she was afraid for her life, and that at least one point, her entire body went numb. So that indicates a temporary incapacitation that not only is sufficient to establish a felonious assault, but because there's no competing testimony in the record at all, is not against the manifest weight of the evidence. I would also remind the court, as I got into in the state's brief, that no hospital treatment and no medical records are required to show that somebody has suffered serious physical harm to establish a felonious assault. So medical documentation is not required, an MRI is not required, a sane nurse report is not necessarily required, and you don't have to be hospitalized for any length of time to suffer a felonious assault. What's required is some kind of temporary incapacitation or temporary disfigurement or something else that meets the statute. Regarding the question of the victim's credibility, I would remind the court that there was no competing testimony at all to contradict the victim's testimony. She was extensively cross-examined by defense counsel concerning the variations, which the state posits were minor, the variations between what she told the sane nurse and what she told the jury in testimony. The state posits that the testimony was actually consistent with and only varied slightly from the statements she made to police and the sane nurse.
Counsel, you said a couple times that there is not any competing evidence, but yet that's not necessarily required in weighing the evidence. There still could be, just like you said, through cross-examination, inconsistent statements, inconsistent testimony. The jury might have looked at the victim and just thought, she's just completely unbelievable. I remember Judge Barrett on the bench used to say, maybe she was winking when she was making the statement. So it's not necessarily that we don't have any competing evidence from the other side to contradict her.
That is correct. But none of the cross-examination in this case gave the jury any reason, or now this court, any reason to disbelieve that victim. So generally there has to be something that would reasonably cause the jury to disbelieve her. And I can give you an example from popular culture. We all see the movie My Cousin Vinny, we all think about the expert witness qualification. But there's another important part of that movie that's relevant to this kind of analysis. And that is where you have the lady on the stand, and she says that she saw the defendants go into the crime scene before the crime was committed, and that she was about 100 yards away, or 100 feet away, I can't remember which, if it was yards or feet, and that she saw them clearly enter the crime scene. And so Vinny, the attorney involved, he goes to cross-examine her. He hands her, first he starts talking to her about her eyesight, and he asks her whether she wears glasses. And she puts her glasses on, and they are thick. And he asks her whether she can see very clearly with those glasses, and she thinks she can. So what he does is he takes a tape measure, has her hold one end, and walks to the back of the courtroom with the tape measure, which indicates that it's only 30 feet back. And she's saying she saw the defendants clearly from 100 feet. And he asks her how many fingers he's holding up. And she thinks there are double the number of fingers that he's holding up. Now that's an illustration of the difference between sufficiency, which is her original testimony that she saw them from 100 feet, and manifest weight. What Vinny had done was given the jury a reason to disbelieve the testimony that she had just offered for the state. She wasn't lying, she just was inaccurate. And he showed how she was inaccurate. There's nothing like that remotely in this case, and I'm not saying that there would have to be a one-to-one, nobody's holding a tape measure in this case, obviously. But that's the kind of concept that you're looking for manifest weight. Is there some reason to disbelieve, or that the jury should have disbelieved the testimony? And in this case, there is none. So, and I would also say to this court one thing. She said is enough. It should be enough that a witness avers to the truth. We often hear that he said, it's a he said, she said case. She said is enough. Now, Judge Carr, I'm going to get to your question about consolidation of cases. I just want to make this brief point, and that is that if the Medina County cases, which were two separate offenses committed against two separate victims, were brought under the same case number and therefore tried on the same trial, if those had been brought as separately case numbered cases, they would not necessarily have been consolidated. They would have been joined, or could have been joined for trial, probably over the objection of counsel, okay, by the defendant. So they would not be consolidated. They would still have been separate offenses. They could not, because they were separate victims and committed on separate dates, and very likely, without having read the record, committed with different animus and possibly even different harm, they would not have even merged for sentencing. So the state posits those are still separate offenses, but more importantly, considering the sexually violent predator specification that was before this court in Summit County, is that there is another factor involved in determining whether somebody is likely to engage in future sexually violent offenses, and that is a catch-all of any other relevant evidence. And the conviction that Mr. Queen had in Medina County was before the trial court, and that conviction included a finding by the Medina court that he was at that time a sexually violent predator. So the same finding was made by the Medina court. That's something that would not be res judicata on our Summit County court, but it was something that court would have considered. And so on that basis, the state submits that this is a conviction for which there was ample support, so sufficient evidence as to every element of the offenses, and then also that none of the convictions were against the manifest weight of the evidence. And unless the court has any further questions, I think this is a relatively discrete and simple case, and so unless the court has questions, the state will urge you to affirm, and I will sit down.
Seeing none, thank you.
Thank you.
Your Honors, unless any of you have specific questions, I'll rest on my brief.
Seeing none, thank you as well. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which the clerk of courts will mail to each party on the day it is issued. It will also be posted on the Ohio Supreme Court website.